Okay, so these slides will be shared as well after, so don't worry too much. So when you first get the moot problem, I would firstly familiarize yourself with the facts of the case and the grounds of appeal. If it's a really detailed moot problem, I would try and break it down as much as possible. Sometimes the timeline will be relevant, sometimes it won't. If it was a contract problem, the timeline would probably be very relevant. Other times not so much. And also the grounds of appeal, because the grounds of appeal are the things that you are either going to be arguing if you're the appellant, or if you're the respondent, you're going to be arguing the opposite of that. Usually a moot problem only includes one ground of appeal or ground of response, so you need to make sure that you also make your own grounds of appeal or grounds of response if they're not already provided. So take note of any cases or statutes that are mentioned. This is kind of the starting point. And then you can do your research after you know what those are and maybe any cases that they cite. And make sure you know which court will be hearing your case, because you need to know what cases are going to be binding upon it. You don't want to have a court of appeal moot problem, but then you're arguing Crown Court cases, magistrate cases. They're not going to be binding. And read any cases mentioned in the problem. That's where you want to start. See what cases they apply, see what cases they distinguish, and do some brief research about the law of the problem if you're unfamiliar. This is a really great point to use the textbooks that you have to ask any lecturers any questions, or just Wikipedia if you're really completely lost, because it's a great place to start. You just want to start somewhere.
Not official advice.
That is official advice. Use Wikipedia.
And someone's asked if the slides will be available. Yeah, they will.
Is Robin back?
I am, yes. Hello.
Robin, do you want to take the wheel?
Right, okay, so our next slide is on researching the law. So this is one you've been given the problem, you've familiarised yourself with it, and you know what you need to do. And then this is a little bit when you're working with your partner. I've put on the slide here that you should identify approximately 3 distinct points of your submission that you want to focus on research. I would say that any more than 3 is possible if some of them are, but you need, when addressing your points, you need to make sure that you can have enough time to develop them all to sufficient level of detail. If you do 2, you run the risk of having them underdeveloped and not a varied or nuanced enough submission. So 3 is a good number. If you have 4, then you run the risk of not being able to develop these cases very well, or running out of authorities for all of them. I think because you only have a limited number of authorities, try not to spread yourself so thin. If you've got 4 points and 4 authorities, you only have 1 authority to back up every point, perhaps. But if you have 3, you can have 1 bigger point naturally that you can develop with a few. Sorry, that's a bit rambly. When you have your 3 distinct points of submission, you then need to start to select authorities to better back up your arguments and really articulate what it is that you're trying to say and what point you're trying to make. A good starting point is the cases and legislations that are cited in the problem. They are there for a reason. Definitely do not neglect researching them and using them as a starting point. From that, you can widen your research to include other authorities. And a really good way to do this, which we'll show you in just a second, is using Westlaw to help you go into these cases and then see where they've been cited before and see what cases these cite. And you can also filter search the cases on Westlaw to see which ones refer to specific pieces of statute or legislation. I would say when you take your case, be it the one that's in the problem or one that you've researched, find out exactly it is that all the judges are saying. The best submissions have taken bits out of the judgment, and then they can refer to what this particular judge says and who's affirmed this statement. Try not to use really lengthy dicta or parts of the judgment. That doesn't really aid your argument too much, because then if we want to hear their opinion, the judge would simply read their judgment, and they're here to see how you're taking what they've said and using it and bending it and weaving it into your submission. So choosing cases, it's rightly added there that cases should have similar facts to the problem. Whilst the facts, it doesn't all hang on what the fact says, and the judge I know might say they're not interested in the facts, or they'll ask you the facts are relevant. It's a lot more persuasive if you found a case that's very similar. So you can say, well, in this case, if this was a judgment, why should this not apply to the case before the court now? What is so different about this case? It means we can't follow this very similar judgment. More recent cases, again, is more persuasive for obvious reasons, really, and binding cases, as previously touched on, again, Although cases that are persuasive can be used, so like much credit, it's going to be a lot better if the cases are binding, and the court will be much more inclined to see your point of view if it's a binding judgment. All of these things aren't always possible. It's not always possible to find a case that's bang on, got exact same facts, and don't worry if you can't do that if that's not the case. But if the aim is for it to be very similar, to be binding, to be fairly recent, to be well interworked with your point, then that obviously is going to really support your argument. Thank you. No, Kelsey, yeah.
I don't mind.
No, you do it. I just got stressed as a pause.
So including cases, for every case you want to use, make sure you have the correct citation. We've kind of gone over that before. It should be in the last PowerPoint. But you can also Google case citations and how to say them, so they're never just read, Donahue v. Stevenson, 1932, UKHL, 62, or whatever the page was. They're always kind of said as the name, and you should use and or against, depending on the jurisdiction, and then reported in or heard in, the year, the court that it was heard in, and then whether it was starting at page or whether it was the case in that year. So you should also know whether it's binding or persuasive. This is a very common question from our judges, and we expect you to know whether it's binding or persuasive. If you're asked during your moot, and you haven't looked it up before, or you're not sure, look at the court that the moot is in and the court that the case you're using is in. It'll be very obvious if it's binding or persuasive. So if it's the same court, it's usually persuasive, and if it's a higher court, it's binding. But also make sure that you have the jurisdictions right, because a House of Lords Scottish case will only be persuasive on an English court, even though it's House of Lords or Supreme Court. You should also know the facts of the case, the parties' names, the year, the issue in the case, and the outcome. The judge may ask for this, so be prepared. There's a lot of spelling mistakes in this PowerPoint. Sorry. And you should know the ratio decidendi, which is the main point of the case, because what you might be quoting might be obiter. It might just be a passing comment that a judge has made that isn't binding. It might be a dissenting opinion. So you need to know the actual rule and piece of law that decided the case. And also you should know the judges you're quoting. Please make sure you're quoting a judge. We have had a few people quote lawyers and solicitors in the moots. They are not legal authorities. We don't care what the lawyers say, we care what the judges say. You should also know if there are any dissenting judges in the cases. For example, in Donahue and Stevenson, 2 out of the 5 judges were dissenting. So if you're quoting from these, while it's authoritative because they're House of Lords judges, it's only going to be persuasive.
Okay, so now we're going to touch on working with a partner. I would firstly like to say of the 4 or so moots that I judged, maybe I think it was more at the end of it, I saw some really good examples. And I know I'm only referring to the Dundee students who did internals, but really good examples of team working. And I would like to say that it's very obvious to a judge when a team is familiar with each other's arguments and when they're sitting there and they've got no idea what their partner's about to say. I know it can be very difficult to find time to work together, but even if it's just a calls chat, not only can you bounce ideas off each other, but just by sharing your points, splitting up what you want to say, you can find it's really coherent. If the judge asks you one thing in your submission, you can refer to something that your partner's in briefly to say that your partner's going to come onto it, and you can work on it like that. Don't worry too much about knowing their argument inside out, but if you're not familiar with it, it's very obvious and it doesn't look very good, because you do get marks for team working, and it's a shame to waste easily achievable marks. So when you do begin to work with a partner and you have all of your statutes and your legislation, your cases and what have you, that you want to include, you'll more than likely find that it's too many because of the limited number of authorities that you have. So your first task would be to narrow these down to the most relevant and then split them up into the points that you're trying to make. If you've got 3 points, you need to split them up appropriately. When you are splitting up your points of submission, remember that the junior and senior have different time restrictions. So I think in the internals, the junior had 5 minutes and the senior has 7 minutes. Yeah, that sounds right.
Yeah, that's right.
And the junior and senior also have very different roles. So the junior will have to introduce the argument and give a brief overall of the 3 points. Let's go over 3. The 3 points that the submission as a whole is going to make. And the senior will have to do a very concise, well-packaged conclusion and summary of the 3 arguments that are made. So it depends how you want to split it up. If you've got one point that really needs a lot of time to develop, you could consider giving that to the senior. I think it works better, in my opinion, if the junior takes on the first point and the senior does the 2 other ones. That always looks better. I think if it is a longer speech, you are really expecting the senior to be having more, I don't want to say more weights, but you've got more time, so I'm going to say more weight anyway. But also consider the chronology of the submission as a whole. If you've got 3 points that go well together and they're very coherent, it might make more sense to introduce something before another thing. Don't throw something in that hasn't been adequately explained by your argument. So just consider that. So it might be a case of moving things around a bit, or restructuring it so that the senior is leading on from the junior. I think the senior should always lead on from what the junior said. And that again would be a good example of team working. If the senior stands up and says, leading on from what my junior colleague says, it's easy marks to get, and it is just common sense, really. The last point I put on here is to consider what your colleagues across the bar may submit and reflect consideration of this in your submissions. This is really for not more advanced mooters, but more experienced mooters. When you're writing up your 3 points submission, undoubtedly you'll look at your point and think, maybe the law is a little bit on the other side's better, or maybe this is an easy point that they would make. And if I was them, I'm not saying spend too long doing this, but if I was them, I would use this case and I would argue this. If it is clear to you that your opponents will be doing that, and there's a sort of well-integrated way that you can, without adding extra authorities that you don't have, consider this argument in your own speech. So you could say, although it could be said, we respectfully submit, or the respondents or the appellants respectfully submit that. And it doesn't have to be a really detailed rebuttal. I don't think this isn't the same thing as a rebuttal, which we'll touch on in later sessions, I'm sure, as you become even more experienced. But showing consideration that there are 2 arguments to be made and reflecting why your argument is stronger and more valid is a skill that every very well rehearsed mooter has.
At this point, guys, I have to head, unfortunately. I hope you found the session useful, and Kelsey and Robin will be very capable of doing the rest of it. So see you later, guys.
Bye. Bye. She's gone.
So this is just a little bit carrying on from Robin's point about structuring your submission. So the junior and senior do have certain roles, so you need to provide an introduction and a conclusion. A lot of people have ran out of time in their moots and not provided me with a conclusion. Even if you're out of time, just ask the judge if you could briefly conclude. They'll usually let you. I would never not say a conclusion unless the judge says no. So think about how the authorities you're using contribute to your argument. And also, think about structure. Some things will be really obvious, especially in the duty of care. You're going to need to prove that there was a duty of care, that it was breached, that you can still get damages, blah, 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 blah. And every time you quote an authority, it needs to add to your submission. And you need to explain to the judge how and why it applies to the case at hand. So there's a little bit of structure there. You want your ground of submission, then you want the application of the legal authority, and then how it applies and how you're relating it to the case at hand. So there's just a little example. I'm not going to go through it because you can all read and you'll get the slides, but you can kind of see in the different colours how I'm using the quote that I've highlighted and the judgment from Lord Porter to relate it to the case at hand and really hone in on the point that I'm trying to make. So you can all see that. That's great, but just think about that, and that's what your structure should be. It should be introduction, and then you say, what is my ground of submission? What legal authority am I using? How on earth am I relating it to the case? How am I making my point? And then like a little conclusion. And then you, depending on if you're the junior, you'd probably do that twice. If you're the senior, you'd do it 3 times, and then your conclusion at the end. You want to do this one?
Yes, sorry. Sorry. finishing touches. This is really for when you've written your speech as such and you are getting ready for the big day. You do have a time limit, and that is very important. I know there's been a lot of submissions that I've seen that seem to disregard the time limits or haven't really focused on it. A submission that's too short runs the risk of looking underprepared and underdeveloped. However well constructed your argument is, if it's 2 minutes short, it's 2 minutes short and it looks like it wasn't researched enough. And if it's too long, it doesn't look very organised. I know that sometimes this will be because of judicial intervention, and I'll touch on that in a second. But as Kelsey said, even if you do run over, which do not aim to run over, but even if you do, the judge will likely stop you and ask for a brief summary. Well, you can offer a brief conclusion. 9 times out of 10, the judge will allow you to do that. It'd be very unusual, and I've never had experience of that personally, of a judge saying no, stop, that's no. When you're timing your submission, read it aloud, read it at the pace, controlled pace, and allocate about a minute to spare for judicial intervention. When I first started mooting, I spoke really quickly. I still speak very quickly now, and I have to remind myself not to. When you have, I would start with your printed or written submission, and then I would, like, you know, with /, I would add forward slashes when I'm reading it out, and I've read it out a few times of, this is a good place to pause, not to a crazy sort of level, but just seeing a slash and it'll help you control your pace. And really, the more times that you read out your submission, the easier it'll become to sort of slow yourself down a bit and control your pace. And a good indication of a really well controlled and rehearsed mooter is the style of speaking and how, you know, they control their own pace. So yeah, I would do that. Also, what I would consider when choosing where to pause is that the judge is going to ask you judicial intervention, and it might be a good idea to subtly preempt where they might ask you things. And what I really mean by that is, whenever I'm sitting in the court and I'm judging a moot and I suddenly realise that I've got a really good question to ask the mooter, it's a little bit difficult and it's a little bit uncomfortable to cut across them. I don't really like doing it, and most judges won't like doing it. But if you've got something that you know is a little bit contentious or is an interesting point in your submission, pause, and then the judge can jump in and ask you a question. And it's a good way to sort of control when you'll be asked a question, and it's a nice way to stop yourself being massively caught off guard. So that's one piece of advice I'd have for that. When you're reading out and you've typed it, typing it or writing out is very different to reading out. You might read through something and say, God, that makes no sense. That's absolute waffle. I'll take that out and just strike it out, just take it out. If you feel like it doesn't really make sense when it's read aloud, it sounds different out loud than in your head, strike it out. Rehearse with your partner, just so they're familiar. You don't have to do this loads. I'd mainly read it aloud in front of the mirror, and it feels weird and it's not comfortable, but you just have to get used to it. And then I'd read it in front of your partner, and they might have more advice like, that bit didn't make that much sense, or pause there. Then when it's right before the day, think about what you're going to bring to the courtroom. If you bring note cards, that's nice because it's compact, but are you someone who's going to fiddle with their fingers? Are you going to flip through them and then get lost? There's some problems with note cards, you know, they're going to fall everywhere. What if the judge asks you a question and it's from like 3 note cards ago and you've got to flip through? It looks slightly unprofessional, but if that's what you're comfortable at this stage, give it a go. I always had a printed version, but because I'd read it out so much, I didn't feel the need to read off a script. There's nothing wrong with bringing up sheets of paper. Lots of people do it. I would split it up into lots of short paragraphs though, so you don't, even if you can physically see, you need to stop and look up, so you're not just reading off a long bit. But again, the more times you read it loud, the easier it will get, because you'll just be more familiar with what you're going to say next. Don't feel you've got to memorize it in your head. I would actually never encourage you to memorize it in your head, because if you ask a question and you have to stop mid-track, it's going to be hard to pick back up. When I first came from school, because a lot of time when I did speeches, I had it in my head because I couldn't hold notes and no one was going to ask me a question, so I could just control my own pace. Mooting's very different to public speaking, so just bear that in mind. And then this is a little tip that I picked up from watching some of the Dundee's internals, is that it's really encouraging to see mooters who have developed their own style, and it's, you know, quite an early on stage. One really good way to do this is to underline key words that you'd like to emphasize to the judge. because you can't really in your speech give your own personal opinion. The judge doesn't care what you think, but you can indicate how you feel about things by underlining things that you want to stress, words you want to stress and emphasize that give a sense of personality and a little bit of a flair. And lastly, come prepared to give the facts and citation of each case. You don't have to include this in your speech, but you could even write it out and then highlight it in different colours. So if the judge cuts across to you and says, could I have the facts of this case if they're relevant? You have them. You don't always have to offer. So if it's Donahue and Stevenson, you don't always have to offer, particularly if you're the last speaker and the first speaker mentioned them, don't offer it because they've already heard it. But if on the offhand they decide they do want to hear it again, you've got them, then you won't be panicked, as well as the citation. So yeah, that's on that slide.
Yeah, just some common mistakes. Yeah, sometimes you get facts of the case and they're 1 minute long and you don't have time for that, especially if you're the junior. Just don't waste time on facts. You can write them out all and you think they're all relevant, but then cut them down. Like if your speech is too long, cut the facts. That's the biggest thing I can say. And you need to know the key points. If you're just telling me everything and the facts are not relevant, then you're just wasting your own time. Yeah, the introduction of the submission doesn't clearly map out the argument. This is really important. You can use your skeleton argument if you've made one to lead the judge to it. I'm more of a visual learner and a visual, than an oral person. So if you tell me them, I will forget them in 2 seconds, like a goldfish. But if you tell me where they are in your bundle, I can look at them, I can see, right, that's when they're going to mention that. Those are the cases. Grand. So make sure that your introduction is clear and that it sets out the points, because then the judge knows where you're going. Don't forget to also, in your submission, make it clear to the judge when you're breaking up your submission. You can even just say, if my lady has no further questions at this point, that concludes the first round of submission. I would like to move on to the next round of submission. And that also lets the judge know that now is the time to ask the questions, because it gives you a pause as well. And you can think and take a drink or something. Yeah, the conclusion is too rushed or too lengthy. I asked, someone ran out of time and I told them they could give me a brief conclusion, and then it went on for about 1.5 minutes. And I was, no, brief is 2 sentences, please. The speech is too short or too long. Although you may have planned a 5-minute speech and then you speak a bit fast and the judge doesn't ask you any questions and you've only spoke for 3 minutes, you need to be able to be flexible. So prepare parts of your speech that you might not say, but if it looks like you're running out of time, you can add back in, because this shows flexibility and that you're paying attention and that you know you have to use up the time. Again, if your speech is too long, have bits that you know that you can cut out. Too many authorities and have not been included in enough detail. This kind of just relates back to Robin's point about how we don't just care about the authorities you use. We want you to be able to apply them and develop them. Yeah, and no pauses for judicial intervention. Again, just make sure you can break up your argument and what you're saying and allow yourself and the judge time to breathe and think about what you're saying. And the mooter hasn't considered key parts of the problem. So if there's some parts you don't understand, and you just think it's best just to ignore them and hope that the judge doesn't ask, that may work sometimes, but other times it won't. So do try your best to understand the problem, talk to your partner, maybe ask a law teacher, and just be like, I'm doing this moot, I don't understand this part of the law. They'll more than likely help you. Do try to use authorities out with your textbook. Maybe a journal article on the topic, if it's a really contested point of law, could be helpful. But yeah, there's always sources out there, and you're probably not the only one that has misunderstood it.
And now, common concerns. This is for a lot of things that we get told from mooters, especially things I was worried about when I first started mooting. So if you feel that the law is not on your side and you are struggling to create an argument because of that, please do not worry. The judge in your court will be very aware if the one side is a little bit easier or the law is more in favour of one side. But we're not really judging you on your well, we are judging you on legal argument, but you're not necessarily winning on the law. It's more about how you responded to the problem and the legal argument that you conducted as a response. You're marked on a various number of things: legal research, team working, your presentation skills, your bundle. All of these things add up. So don't feel that because you're on the losing side, it's, you're going to lose because of that. Because the other team, your opponents, could have a more straightforward path to research, but because of that, their submission maybe was underdeveloped. They hadn't thought of things that you'd had to think about, or maybe their style of speech isn't as sophisticated as yours. And there's also no one correct answer. If you've done enough research and you've planned it out and you've structured it well, you can easily be very persuasive to the judge. It's all about getting the judge to see where you're coming from, see your argument, and see if they really agree with you based on that. So if there's it's like with many legal issues, there's no one correct answer. So please don't try and worry about that. Try your best to construct the best possible legal argument you can and use that to persuade the judge to see your point of view and see why you should win based on that. They do naturally tend to lean in favour to one side, but yeah, try and show off your legal creativity. That's especially, I would really say that if you are on the weaker side in terms of the law, it's more impressive. You've got more of a chance to show off and really impress the judges, that because of that you've had to think outside the box and come up with potentially a more sophisticated answer. So please do not worry about that.
So yeah, that's all the slides we had. I'll go through Westlaw in a bit, but yeah, just as Robin was saying, I feel like a lot of the times I marked the moots, it never really came down to your legal argument. It came to your presentation. A lot of the times it came to time limit and maybe the style of speaking or the order that your argument's in, but never really. There was never a time where I was like, they clearly have got all the wrong cases. But if you have a bad case or you have a bad argument, it's more likely that the judge is going to ask more questions to clarify. And if you can't handle judicial intervention, that's where you're going to fall down. So
yeah, some of the biggest aspects I would really say are judicial intervention and presentation. That's really where people seem to get caught out, or their bundles as well. Not really so much for the legal, well, the law.
So I'm just going to go on to Westlaw now. Anyone want to shout out a case for us to look at? Or will I have to come up with one? No cases? Okay, we'll do, I was doing this one recently, but I don't know how helpful it'll be. Oh no, maybe. Okay. So if you want to find a case, obviously you know how to do this. You can go onto the case and go into this precedent map and treatment. So it'll let you know what the case has been treated like, if it's been overruled, what cases it previously cites. This is kind of a small one because it's quite a niche case, but we can see all the previous cases that have been applied by it and what their facts are. So you can easily find cases which may go further back and kind of establish rules of law. So cited cases, citing cases, all those things. So it's good just if you don't know where to start and you have a case like Donahue and Stevenson, you can see what cases have been applied by it by using these tricks. And that's kind of an easy way for you to broaden your research and maybe find a case that has more similar facts than the case that the problem has or the case that you found. So that's something. We also had a little bit of trouble with getting Westlaw reports, like Robin said. So say if we went to this case, the Westlaw report version would be you going here and downloading the page, but we don't want to do that. So if you click on these ones, this is again the full case. And some people might have used this because obviously it has all the paragraphs and everything, but the best thing to do is to click this little Adobe button, and it will open the actual report. And this is what we'd prefer to see in your bundle. It looks more professional. It doesn't have any of the Westlaw bits, and it's actually where it was reported. So in Weekly Law Reports, beginning at page 47, or in the England and Wales House High Court. So that's good. Now, if you have no idea where to start, the bundle hasn't mentioned any problems, you're totally confused. So say if the moot problem was on contract, you can type in a subject keyword. So you can say contract. That's going to bring up a bunch of cases, 10,000. Please don't look through all of them. So say it's, okay, so you can click contract here, breach of contract, contract terms, contractual rights and duties, formation. So say we're looking at a case about whether they formed a contract, so we have to look at intention. You want to look at formation of contract. So there's a lot. We can see that was the Chancery Division, not a very binding case, Court of Appeal, that's good. Chancery Division, so these all look English. So we say, how am I supposed to find all the Scottish cases? So you can go down here to jurisdiction and you can type UK and then Scotland. So there's all of the Scottish ones. So we can see this is about kind of, these are the keywords that it gives you. So if you're looking at those going, oh, that doesn't look like what I want either. No, that doesn't look good. Offers and repudiation sounds maybe like it. Again, look at these sheriff courts. So you could start here, but it might not be the case you want to use in the end, but it could lead you to a case that you think is good. So this one has a positive judicial consideration, which usually means it might have been used a few times or it's been considered good law. So again, we could see the precedent map, or we could see even like the primary references that it's used. So you can see every case that it's already cited and how to download it and what the summary is. Maybe some books that it's been cited in. So we'll just look at the precedent map again. We can see it's been a lot of application recently. So these are some big cases that have maybe been applied in this case. You can see that's a Supreme Court case. So maybe that's that could be useful to you. I hope this is making sense. If any of you guys have any questions or you want me to show you how to do anything on Westlaw, let me know. But I think it is worth just having a play around. And yeah, I mean, when I mooted, I feel like I looked up so many cases and had to read through them all. And I know they're long. But oh, here's a trick as well, actually. Okay, so I downloaded let's download this one. Not entirely sure. Yes, it will always be 5 authorities. I mean, I'm doing a competition right now where it's 4 authorities, and I thought that was really harsh. Usually, though, you'll get 1 or 2 in the problem, and that includes legislation. Oh, that's annoying. Sorry, that was blah. So sometimes you can't get the Westlaw, sometimes you can't get the non-Westlaw version, and you have to use Westlaw, and it's fine. We understand if it's physically impossible for you to download it. Okay, so once you get a case, you know, oh, this one's 48 pages, look at that. No one wants to read all of that. So we can kind of see what's been held. So the best thing would maybe be to start here, or you look at the facts and you say, is this relevant to what I want? Say you're looking for something relating to intention. You could type in intention. So this is interesting. You kind of just like look through them, see if there's a good quote by a judge. Obviously, where does the judgment start? So the defender's submission, all of this stuff is by the lawyer. You shouldn't quote it because it's not legal authority. We want to find stuff by the judge. A lot of mooting is just reading case law. unfortunately. There's a decision. So in this instance, it's a very small one, but there might have been. So yeah, because it's a small one, you're kind of like, oh, maybe this isn't the best case to use regarding attention because I just can't find anything that the judges said that's important or relevant. So let's do another one. So you could also start here. Maybe you're unfamiliar with the law on, I'm doing one currently about criminal damage. So you're unfamiliar with the law on criminal damage. So you just type in criminal damage in the search bar. There's an article. So that kind of explains what the legislation is, the statutory defense, some important cases that were to start. Obviously, you're not going to cite this as an authority, but it is a good place to start, and it does let you know, oh, these are some certain facts in relation to criminal damage that I might find useful. There's also some legislation that I might want to quote. So that's kind of how you do it. Does anyone have any questions? I really do recommend having a play around on your own. You can look up topics, jurisdiction, date. So if you wanted a really recent case, there are other ways to get cases like LexisNexis and things. I don't really like to use them because Westlaw tends to give you the PDF of the case, and LexisNexis doesn't. But yeah. So if there are any other questions, feel free to ask in the chat. I'm currently doing a moot, as I've mentioned, and the law isn't really on my side. There's no legislation. There's no good authorities for my side of the argument, so I'm really having to just be legally creative and saying to the judge why we should basically move away from that law and onto a different side of law. And although you may think, oh, we're going to lose, we're going to get asked loads of questions, you just have to realize that you can prepare answers for everything. Like if you're worried about judicial intervention, think of the questions that you're going to be asked and just write the answer beforehand, or just know your argument inside and out, and what you're saying. You're the one that makes the argument. So I'm kind of expecting you to know if I would ask you a question. Yeah, that's a really good question. So if the law isn't on your side in this jurisdiction, is it okay to use precedent from another legal system where they've done something more similar to your side? Yeah, exactly. So if you think, I mean, currently I'm just going to give my example, it's an objective test in criminal law to using a defense. So I'm arguing that there should be a subjective test. Now, I could look to other jurisdictions that used to have an objective test and have moved to a subjective test, or jurisdictions where it's always been subjective. And then I can use their arguments and say why it's more fair for the accused to be tested subjectively. So yeah, that's a great example. I'm trying to think of any more. Obviously, you need to find cases where the facts are really similar, and you need to make sure that it really does benefit your argument, because the judge is going to know that it's a non-binding case. But it's perfectly okay to use other jurisdictions if you have to, but try and make sure that they are quite high up jurisdictions or have similar facts. I wouldn't use legislation from other jurisdictions, so case law is fine, I think. And the ECHR is a good one, so the European Court of Human Rights. Any other questions? And I know that legal research does take up a lot of time, but you have your partner, you should be splitting up work with them, trying to find cases, so don't all spend time looking up exactly the same cases, because you'll be wasting each other's time when you could have been collaborating well. Usually when me and my partner do research, we would kind of both research all of the case, but we would kind of send each other the cases that we find, so we can read them together and we can pick quotes, and then we decide which argument, junior or senior, we feel most comfortable saying and kind of decide on that. Usually it turns out that she would like the junior one time, and then the next round she would prefer the senior, and so on and so forth. So it does mean that one of us isn't always the junior and one of us isn't always the senior. Would it still be reasonable to use anything from European law then, since we're still in the near post-Brexit period and we haven't set up one-to-one like replacements for legislation yet? Yeah, but then you're still, everything that the EU gives us usually has to be ratified in our own law, I think. And also, I'm probably not going to give you a moot problem on EU law, just because I don't really understand it either. And it's a lot to do with trade in my mind, I think. But European law, ECTHR, European Court of Human Rights, has nothing to do with Brexit. So you can use those. Those are fine. If that makes sense. And yeah, you'll be told if you go on the government website and use a piece of legislation whether it's been overruled. So that should be fine. And do ask me if you really are not sure and you'd be like, is this still an authority? Just send it to me and I'll be like, no and yes. And use each other. And use your lecture. Just talk to everyone about mooting. So that's kind of all I have to show and talk about. But if anyone does have any questions, feel free. I can stay on as everyone leaves. The slides and the recording link will be shared with everyone, so don't worry too much.